And we're live. Hello, everyone, the viewers tuning in, and this esteemed panel. This is episode 4 of Do Your Own Research, our new panel, new show between the Defiant and IC3. And yeah, today is a very fun one. I'm very excited to dive in. So we're joined by Hester Peirce, SEC Commissioner, Caroline Malcolm, VP Global Public Policy at Chainalysis, and Professor Carla Reyes, Associate Professor at SMU Dedman School of Law. How is everybody?
Great to be here.
So yeah, I think it'll be good to get the ball rolling with just an overview of, or a definition of good versus bad regulation, because there's a lot of talk a lot of the time about what is good regulation. We need regulation. And Hester, I'd love to start out with you because you are in the trenches of that question. If you could give us a definition of what you consider to be good and bad regulation.
Sure, and let me start out by saying that I'm first of all happy to be here, but second of all, I've got to give you my disclaimer before I can say anything substantive, which is that my views are my own views as a commissioner of the U.S. Securities and Exchange Commission and not necessarily those of the commission or my fellow commissioners. So I think that is a good question. What is good regulation? Because a lot of people have been calling for regulation, and I think people have different views on what might work and what might not. I think when I look at regulation, I don't think of it as being the first thing that we should leap to when we have a problem. But I think that it can serve a valuable purpose. So first, we should identify a problem that we're trying to solve. And then we should look at whether we need regulation to solve that problem or whether the market will solve the problem on its own. If we don't need regulation, the reason that I sort of hesitate to leap to regulation is that regulation typically distorts behavior, and it can distort behavior in a way that is actually bad, on the net bad instead of net good. So I think that's where you're trying to get, is if you decide there's a problem, you need regulation to solve it, you got to look for something that has more good consequences than bad consequences. And that can be hard to tell in advance. But, certainly trying to take a more principles-based approach that allows people latitude to do what they're trying to do, to achieve what they're trying to achieve, yet, serves the basic. We have 3 missions at the SEC: protect investors, facilitate capital formation, and foster fair, orderly, and efficient markets. So if we can achieve those objectives while still allowing people a lot of latitude to make their own decisions, that's good regulation from my perspective.
Would you agree with that, Caroline? And I could you give us your idea of what bad regulation looks like, especially from a private sector perspective?
Yeah, so I think Hester makes a good sort of first question, like identify the problem, and second, is regulation the solution to that problem? Because there's actually quite a number of different mechanisms, and particularly if we think about areas like, say, the internet or the digital asset industry, you can see that there's a number of forces at work there, and there's been a lot of sort of theory written about this in terms of you might need some regulation, but you're also looking at the market forces. You can look at what can be done by design, sort of by code, and you can look at sort of the establishment of norms and how those are developed, and so how you push behavior forward. There's a number of different levers. We often think straight away about regulation, but in fact there's a number of different levers we can consider when we think about affecting behavioral change. I think when we do though get to the point of, okay, we do think regulation is necessary, I think, first and foremost, I think what we hear predominantly from industry, and I think this is true not just in the digital asset world, but in kind of business at large, is that clarity is really one of the most important things. So understanding what I need to do and what I can't do is really, you can then make investment decisions, you can make business decisions, you can sort of determine where to deploy resources and so forth. But not having sufficient clarity can be very challenging. And perhaps the last thing I'll mention is that often there is a argument that, well, if there's regulation, that means, if we're passing regulation about crypto, that means pro-crypto, and I don't think anything could be further from the truth. We have regulation about banks. It doesn't mean we're pro-banks or anti-banks. It just means that there's been identification of a need that needs to be addressed through regulation. And so I think what's very, very clear is that where we have countries, and the data bears this out really clearly, is that sort of just ignoring the problem or thinking a ban will work really doesn't work for actually addressing the challenges of the industry. You do need to be a lot more thoughtful and actually think about sort of your regulatory, and it's not though a question of being pro the industry. It's really about things like protecting consumers and making sure that there are safe markets.
How does I agree, and I'd love to get Carla to weigh in on how she views it, how you view it from the academia side of things, and if you could give us a sort of zoom out a little bit, because academia is sometimes, for us that aren't in that space, it's kind of a sort of dark horse. It exists, it obviously influences, but it's not entirely clear how it influences. And so what are those conversations that you're having, especially regarding what good regulation is and what bad regulation is?
So that's fair. I think I'd make a couple of comments first. So before I was an academic, I was a lawyer. I've been a blockchain lawyer since 2011. So I often don't think of myself as a dark horse academic, right? Like that's not in my mind, that's like not my identity, but that's okay. I guess I've been in academia long enough to be an academic in the ivory tower, whatever, fine. But but I would say I agree completely with that. I'm a private law person, actually, not like a regulatory public law person. And so I love private law solutions that leave things up to private parties to contract for and to sort of make their own solutions. In fact, most of my writing is all about that and showing how in emerging technology contexts, a lot of the times private law solutions can do the same things functionally that folks hope regulation achieves. I think sometimes when you hear calls for we need regulation, people are really thinking we need law, and they think somehow there is no law applicable to this space, but there's more law than just regulatory law, right? And it's important to keep that in mind when we think about what is good, maybe good law, and zooming out a little bit, what's good law in this space. I'd say when it comes to, if you've decided, yes, there's a problem that needs regulation, which is a specific kind of law designed to solve a specific kind of problem, then I think good regulation, in my view, and what I've been writing about since I was a lawyer, is one that is activities based. So I'm not a fan, and very clearly not a fan in my scholarly work, of regulation or law generally, private law included, that is geared towards crypto. Regulation about crypto, like that's not a thing. I don't think it should be a thing. I don't think we should have a law about stable coins only. We should have laws that focus on the activity that causes certain problems and that guides the activity to avoid those problems or to remedy those problems after it's occurred. And hopefully that activity-based regulation applies regardless of whether you're conducting that activity through high technology means or low technology means. Now, some folks will say, well, that hurts clarity. Then we don't know how to do what we need to do to comply. Only if you're trying to do it on your own without asking lawyers how to do it, right? I think, and it depends, I think, on what activities you're trying to accomplish in a compliant manner. So some things like complying with SEC regulations based on activity, there are legitimate concerns about whether you can functionally comply with the forms, for example, if you're in a certain kind of industry. But generally speaking, I'm not a fan of regulation that defines crypto assets or tries to define blockchain or smart contracts. I've done studies that look at the words used in those laws, and uniformly, they get the definitions wrong from a technical perspective. And oftentimes, the things they're trying to achieve they achieve the opposite, either because they've defined the thing they actually want to regulate out of the law, or because they didn't understand the law to begin with. And so then they created a thing, like they made it worse. A really great example is changes to UIDA in the state level to accommodate smart contracts, when what they really did is make sure actual smart contracts are completely out of coverage of UEDA. So anyway, I'll stop there. I have lots of thoughts about that, but those are my initial thoughts.
Why do you think then, if there's such a misplacement of focus, and we shouldn't be approaching like each specific aspect of the industry to start regulating it, why do you think that the industry then continues to be, we need regulation, we need to keep it very specific, because otherwise, there's not going to be clarity? What do you think that problem comes from industry players that don't understand the law, or that there's just such a desire for like quote unquote clear regulation that it doesn't really matter how it's getting done as long as there is some sort of set of rules?
So I think it depends on which area of regulation you're talking about. I think the answer to that question differs. If we're talking about money transmission, up until very recently, I would have said the law was very clear. But in very like the last year or so, I think the agencies have sort of upended what everyone thought was established clear guidance, right? If we're talking about securities regulation, on the other hand, folks know about the Howey test, but it's not clear maybe how the Howey test applies, when it applies, like that. There is lack of clarity in that regard, but that, frankly, it's the Howey test. That lack of clarity has always existed, as far as I'm concerned, regardless of whether you were a token in an ICO or an Orange Grow related services offering, right? That's the nature of the Howey test. The problem that really I think folks in the industry struggle with, and I think you've seen judges struggle with, right, is that even if you think it is in the initial transaction, the initial offering needs to be compliant, what about in the secondary markets? Right? What happens then? We've seen the conflicting judicial decisions in that regard. And secondly, even if you think the initial offering needs to be compliant, like how though? Not all of the information required to be included in the forms like exists, right? It doesn't fit necessarily for certain token offerings. Those are the areas where clarity is needed, but some of that is just part of the way the law works, right? Does the Howey test apply or not? There's always been a little bit of a lack of clarity. It's judicial test, right? Then, but in the absence of that, this sort of fear of being enforced against all the time, right, raises the concern about that lack of clarity. And then separately, this question of initial offering, secondary market, and how do we comply? Like literally the practical part of how we comply, which isn't actually are we regulated or not? It's how. That's a separate question altogether. That's not about clarity of regulation. That's about the practical, like how do I do it exactly?
I mean, I agree with a lot of what Carla said, but I do think part of the reason that people have been asking for crypto-specific regulation is because, and I'm speaking about my agency specifically because this is the one I know best, but I think the SEC has really mishandled application of the securities laws to crypto, and that has been very frustrating for people. And so, I mean, I have issues. I think that Carla's right. The Howey test it's a judicial test. It's not always immediately clear how it will be applied, but we have applied it differently in the crypto space than we have applied it in other spaces. And we've really elided some distinctions that matter a lot. When we talk about, for example, we're doing the equivalent of talking about the Orange Grove as if it is the security, and it's not the Orange Grove that's the security, it's the Orange Grove plus the contract. And so it does matter when you're trying to think about how the law applies. And then the other thing that I think we've done poorly is that we've just given this mantra, come in and register. And Carla touched on this too. Some of the registration requirements just don't fit very well here. A team that's developing a blockchain with a native token on that blockchain is not equivalent to a company that's going to come in and register to be a public company. And the response is, well, then just do it as a private offering, rely on one of the exemptions from registration. But the problem with that is that the goal of a blockchain is to have network effects. So you want to have lots of people participating in the network. You can't just do a private offering. You don't want to just have it be a few venture capitalists who have the token. You need to have widespread use, adoption of the token. And so we can't just impose a public company framework. We really do need to think, again, going back to the first thing I said, what is the problem we're trying to solve here? And I think the problem we're trying to solve is that we want people who are buying that token to have a sense of whether this developer team is a bunch of crooks, whether they actually have a plan, how many tokens they're going to hold on to themselves. There are things we want to know, and we can design a framework to elicit that information. But it should be a tailored framework that makes sense. And the SEC should start being much more legally precise in how it talks about a lot of these issues. And there are certain instances where we said we have come in later with an enforcement action, but we could have come in earlier and said, we're seeing this activity, which looks a lot like a securities kind of activity. We suggest that you think about these things when you're designing your crypto lending program, for example, whatever it might be. And we just have not done that. And I think it has led people to go to Congress and say, the regulator is just treating crypto differently than it's treated other things. So we want you to come up with something. And I think that's what Congress has tried to do in creating some of these bespoke laws. And I appreciate Congress weighing in, because I think we have mishandled things.
Pedro, if I can, I'd just like to add perhaps a slightly different perspective, which can sometimes get lost, is these issues we're talking about, of course, are very US specific issues, because if we look across the world, of course, we do have regulatory frameworks in place. And in fact, we've had some in place for many years now, whether it be from Abu Dhabi Global Markets, Japan, Singapore, Europe. I mean, these are not small markets, and they now have quite comprehensive, beyond AML, prudential requirements, market conduct requirements, consumer protection requirements in place. And so when we think then back to the US and we think about the challenges in moving forward towards that framework, I think we sort of have to take into account the sort of the impact of the historical situation of having sort of two distinct agencies, which is perhaps not something which you have in other parts of the world. So they haven't faced perhaps that same challenge of coming to an agreed approach when it comes to digital assets.
So I think a couple things. So when you say there's two distinct agencies, you mean in capital markets regulation, right? I want to make sure when we talk about regulation that we're specific what we're talking about, because capital markets, there's more regulation than just capital markets regulation. I understand with the commissioner here, we are going to maybe tend to think use that word regulation to talk about capital markets regulation. But I guess what I don't want to happen in the US is for everyone to think about all of crypto as through a capital markets regulation lens. That would be terrible for crypto, not just in the US, but everywhere. That's just the same way I also don't want the US to only think about regulation for crypto through an anti-money laundering lens. I want the US regulation in crypto to focus on activity. Forget that it's crypto. I want you to focus on activity. And if the thing you're doing through crypto fits the activity, then it's regulable, whether it's capital markets or anti-money laundering, whatever. And if it doesn't, we have to accept a world where maybe DeFi doesn't do the things that is regulable. And if that creates negative externalities that we don't like, then we have to come up with a new way to do law. And I think the US focus, and frankly, the world focus on intermediaries is a really easy way for us to figure out how to regulate things is the problem. Because increasingly, there are at least areas in cryptocurrency and blockchain technology that do not have intermediaries we can regulate. And increasingly, as agencies like the Department of Treasury, like the CFTC, and others find intermediaries where they do not actually technically exist, we harm law broadly. We delegitimize the fact of law, and I think that's a bigger problem than just capital markets, two agencies fighting with each other.
I think that's such an important point, because there is such a tendency for regulators to say, okay, well, we're going to look around and we're going to find someone and we're going to say that person is an intermediary, and we ignore the facts around whether or not that person is actually an intermediary, and it's going to create very bad results. And I have really grave concerns about that. And I second Carla on the point about not thinking about crypto solely through a financial regulatory lens. Crypto is likely to transform lots of aspects of our lives, many of which have nothing to do with the financial markets.
Yeah, Caroline, do you have any specific examples from around the world that you've seen that could serve as some sort of stepping stone for where the U.S. should go, or what you like or what you're seeing that is positive for the industry that the U.S. might be leaving out or might be leaning into?
Yeah, it's a good question, Pedro, but I think, as with most types of regulation, you might have some high-level principles or some particular international standard that you are working towards achieving, but the details of how you achieve it relate a lot to what your domestic policy objectives actually are. So I think, and I certainly don't want to speak for what the US's, policy objectives might want to be in this space, but I think the point to take away, though, is that we do now have a bench of different approaches that we've seen around the world. So if we take the issue of consumer protection, for example, we've got some countries who are, trying particular models with respect to, different ways to limit retail access to the market, for example, or put in thresholds or make sure that there's certain levels of knowledge before somebody can actually access these markets, for example. So you do actually have a very sort of growing bank of approaches that lawmakers can turn to for inspiration. And they've been going on long enough now that you can actually then look to the market and see what effect they've had. And to one of the points that Hester made originally is really look at what maybe some of those unintended consequences were when you did go down a particular route. And then I think, kind of the other aspect I just mentioned briefly, but just to highlight it, is this issue of sort of international standards. We do have, and probably sort of the most well-known and the most well-adopted is, of course, in the AML space from the Financial Action Task Force. And those are other things that countries, including the US, look to when they think about, well, what am I trying to achieve? Because the reality is these things are not limited to any one particular jurisdiction. And there is always this tension between needing to adapt approaches to domestic requirements and domestic objectives, while also recognizing the cross-border nature and the need for at least a coherent, if not necessarily a sort of a strictly, identical approach in different areas of regulation when it comes to digital assets.
I mean, I think Caroline makes a really good point that, one advantage of the SEC waiting, or the US waiting to do something, is we can see what's worked and what hasn't worked. But I think one thing I don't want to get lost in whatever conversation we have around how we regulate in this space is the importance of basic principles of liberty and privacy, and the ability of people to try what they want to do and to use their money the way they want to use it. That's something that's very important in the United States, and I think sometimes we forget that in the rush to try to conform to some international standards, right? And I think that, in the area of financial privacy, we've given a lot of that up in the name of AML KYC regulation. While that is important, it's important for us to have those regulations in place. We also need to always remember that financial privacy is very important to individual Americans, and we got to find a way to balance that. The answer can't just be, we're going to put a mass surveillance program in place. That just doesn't work in the United States. It's not okay in the United States.
Completely agree. Which is why I'm shocked and dismayed by actions against Tornado Cash and other recent events. Like I said, we would have thought up until recently that money transmission law was fairly settled in the States. And last year or so, I think a lot is upended in that regard. I would say there are other areas, national standards, that are quietly being developed on the private law side. Yeah, because we're cool like that. With a lot of collaboration with industry and a lot of long-term discussions that focus on again, on the activity and functional, creating law for function rather than for a particular outcome. Like, we should be able to tell who you are at all times. And I'd be really interested to see if there would, if you could rethink the way we create law, and instead of using something sort of closed off and not as transparent as the Financial Action Task Force, you could, mirror maybe a private law process like those used at Unidraw and other standard setting law endeavors on the private law side. Not to say private law is better, but it is. Just saying.
Well, but I mean, I think there really is something to that point. And I'm a regulator, a government regulator. And so I do think there's room for government regulation. But even with government regulation, you want to do it in a way that involves other people outside of the government, because it needs to be something that works for everyone. And so that's why I say regulation for me is a last resort. If you can figure out how to get to a good place without, through a private law mechanism that allows lots of people to participate, and that's maybe more nimble and maybe more flexible if something needs to change, that's not a bad thing. I'm okay with us being the backstop, not the first place where people go to look to try to regulate things.
How do we bridge that gap, though? Because I feel like a lot of people, everyday users, industry people, executives, startup founders, developers, are entirely unclear of how regulations work, how the law works, and there's a huge distrust towards centralized institutions as is, and even more so in the crypto industry, even more so when we're talking about the SEC. So how do we bridge that gap? How do we get closer towards where there's a better understanding of regulation and what needs to be done? Even, Carla, if you'd like to weigh in, even the language that's getting used to talk about these sort of things, so that your everyday user also understands the needs for these frameworks, the needs for understanding what authorities should be doing and should be not doing, and how innovation can take place in a constructive way for everybody who's involved.
I think the question of high technology startups or emerging technology startups, not just in the crypto or blockchain space, but generally, like, not realizing which law might apply is like as old as, like, that's always been a problem, like, since the .com bubble, right? That's just, I think, part of the growing pains of being a technology startup. That's not a really great answer, but I think it's true. I don't think that's unique to this space. I think the problem in this space is that the consequences are more dire, right? It's jail time, right? That's, if you mess this one up because you didn't realize that you fell in that regulatory box, you're going to jail. That's really where it's harder in this space than maybe in prior emerging technology startup spaces. And I think the only, really, you got to talk to lawyers, but you got to talk to lawyers who know the crypto side. And that goes to the language part. There is a divide, I think, between legal folks who understand the technology and those that don't. And I think that's true for the private bar as much as I think it's true for folks in government as well. I think it's become sort of like, oh, they just don't understand the technology, as a way to say that doesn't count. Like, I don't have to listen to that new regulation or whatever. And that's not always true, but I do think it's real. I think a knowledge gap exists. But I think similarly, that we have this tendency in crypto to, like, everything has to have a cute name. And sometimes those cute names come from law. So, like, a smart contract. And, like, legitimately, I think lawyers were confused about what smart contracts were, and maybe still are, for far too long. Like, it's not that hard to look up what a smart contract actually is in technical terms, but the use of the word contract just, like, triggers people in law. And it come to a realization, when we borrow terms of art from other disciplines and we use them as terms of art that means something entirely different in our discipline, that's going to be a problem. And it's going to be a problem in ways that we might not expect, and in ways that we really dislike the consequences later. And I just, but I do think there needs to be an education initiative. I mean, I think there has to be, I don't know how to say this without like offending everyone, so maybe I just say it, but there has to be like a neutral body. Maybe it's not academia because people don't like us either, but there has to be a neutral body somewhere that is like, listen to all of y'all, everybody in all your disciplines, here's what this means for you, and here's what it means for you, and I need you to like, folks at Coin Center, great job of explaining at a highly technical level what certain things actually are and how it was misunderstood by agency, right? But the government like doesn't seem to listen to Coin Center because it's Coin Center, right? Somehow they've been politicized in a way that's like not awesome for them. There needs to be some other more neutral entity that only does education, right? No lobbying, no nothing, just education that can educate everyone on whatever it is they're missing. Because I do think we've borrowed terms of art from each other, and then we talk and we say it's the same word and mean exactly different things. And I think that's I also think it's a problem. Lawyers make up words. Like crypto asset is not a word. And now there's a whole regulation in Europe that's called regulation of crypto assets. It's not a thing. Like that's not, there is no, I hate that word. And now it's like the leading regulation, right? Anyway, we have to stop doing that too. Taxonomies, no more taxonomies. Taxonomies are terrible. Those things have to stop.
Caroline, are you seeing the same thing around the world? Are you also experiencing this sort of, lack of, I guess, linguistic alignment, to call it in some way?
I feel a little bit more positive because when I think back, before I joined Chainalysis, I set up and led the Blockchain Policy Center at the OECD, beginning in opened the center in 2018, and I remember for a couple of years it was very hard to get anyone to pay any attention really to what we were doing, and it was sort of around 2020 we began running some trainings for government officials. And so if I think back to 2018 and I think about now, then I think we're in a much better place than we were. I see Carla doesn't agree, but I think we do actually have made a significant amount of progress, which doesn't mean that we're necessarily at the end spot. And I think one of the issues she's picked up on and Hester's picked up on earlier is, that this classification of everything in this sector as being, related to finance. And I think if you think of this spectrum where you sort of have a financial asset down one end of the spectrum and you perhaps have a data asset at the other end of the spectrum, and then you have all these things in between those, and it seems that as soon as sort of tokenization gets involved, there's this desire to put it into the financial asset basket, and I think that's, I think that's going to have much bigger implications beyond just the digital asset sector that we haven't really sort of thought through fully, and I think there's a risk that we go quite far down that path before realizing just how many sectors and that we've sort of put under the control of financial regulators a whole lot of things that maybe don't belong there.
So can I just real quick, tokenization, that word is an excellent example of what I just talked about. Tokenization is a thing that's existed for like a real long time. That's not a crypto thing. A check is a token. It's a token that's given specific value via legal mechanism, right? Your deed to your house it's a token. We tokenized the real estate and we made it special by law, right? Tokenization is a concept that's existed in law for like forever. And my friends Juliet Morangello from Widener University and Chris Oden at Texas A&M have this really great paper explaining why that's true from a commercial law, private law perspective. But it's one example of like where crypto borrowed a word, like doesn't even mean what they think it means, right? And for lawyers anyway, right? And similarly, in the payment space, tokenization has been a thing for like a really long time. You don't use your credit card or your debit card anymore without using a token because it's for compliance with privacy standards, right? It's your PAN data is tokenized. That's not a new word, and it doesn't mean generally what people think it means in the crypto space. That's just one example of that happening again.
Hester, would you like to weigh in? Because I feel it would be interesting to get the perspective of somebody, quote unquote, on the inside of the regulators.
Yeah. Well, I mean, I absolutely agree that we need to have better education. And I just this morning was getting a little tutorial from an intern who's very knowledgeable in computer science. But I think having having the ability to hear from people who actually know the technology well. Even, I've been in this job for now more than 6 years. I've listened to countless crypto podcasts. I try to understand the technology as much as my brain allows me to do. But even I can always use another refresher, another tutorial. It does help me. It kind of helps me to kind of reframe and think, okay, this is where the securities laws interact with the technology. And maybe this is where the technology is outside of the securities laws, so I don't have to worry about it. And so I welcome that. And I think there's always room for more of that. So if anyone wants to come give me a tutorial, my door's always open.
Me too. I think everything you said applies to folks in academia writing about it as much as it does for government or for state officials.
Carolyn, I wanna ask you something that we touched on before, which is this whole idea of like this AML framework that we're using a lot in the industry. Chainalysis is obviously, I mean, it's no surprise to anybody here that it's a controversial company. They do controversial things in the industry. They've been, pretty instrumental in a lot of, concerns regarding financial privacy, and just general reporting of how people operate on chain. Would you say that the controversy is in any way substantiated? Like there are claims there that you think are they have some foundation. And then do you also see that there's a concern in this overly AML focused approach to how crypto operates and how people use this technology? You're on mute.
Thanks, Pedro. Look, I'll take them in the reverse order because I think it probably makes a bit more sense. Look, on the AML front, I think a lot of the focus went there initially because that's where we had the first, sort of regulatory frameworks put in place. And so, whether that's a chicken and egg situation is probably I'll let others comment, but the reality is that is why it has had such an initial focus for the sector. And that's not really that unusual. If you look across other sectors as well, often we can see that focus on, so if we think of, say, financial crime, that tends to happen, and a lot more focus will go there initially before perhaps looking at other aspects, other policy themes that regulators might want to tackle when there's a new sector that emerges. So I think it's a pretty natural sort of outcome of the sort of way that regulation develops over time. To come back to your first question, though, I think, if I think about what the mission of Chainalysis is, it's really, to build trust in blockchains by harnessing their transparency. And like crypto held that reputation in its early days of being totally anonymous and untraceable, but that's never been the case. So this is not something that Chainalysis discovered. All those transactions have always been available online for people. So I think that's, kind of the first thing I would mention. And the second thing I would mention is that, I can sort of understand the question because, a lot of the research that we publish, does get a significant amount of attention. And that's because, those reports are, I think, really unique, and they rely on sort of incredibly high quality of data. And that's data that's now been tested successfully in court, if you followed some of the developments over the last 6 months. And so really, though, the idea behind those reports is to demonstrate the transparency and bring that trust in the sector so that, we will over time see, it reach its full potential. So, I think it's important to recall, Chainalysis sort of didn't develop the idea that the transactions on the blockchain are transparent. That is sort of an inherent part of the technology, and it's part of the technology that many parts of the sector really sort of look to and refer back to as part of why they see the value in it.
But would you still agree to or do you still see some dangers of having that sort of on-chain activity scrutinized through the heuristic models that you use? Because I do think, and yeah, before this panel, I was speaking to a couple people that there was going to be somebody from Chainalysis here, and that was a question that it was always asked or was always spoken about, how there are still underlying dangers to sort of analyzing the different blockchains the way they're analyzing. Would you agree that there are specific dangers, or do you think that they're overblown at the end of the day?
I'm not sure if I sort of understand the reference to danger per se. If I think back to, say, the AML situation and the development of those rules and their application, say, in traditional finance, there's sort of been, and this is to sort of something Hester was mentioning before, there is, in the development of AML rules, this balance that has been struck over time. And it's a balance which is not unique to digital assets, but it's really about a balance that says, people do have that right to that financial privacy. And as a society, we have also said that there are some limits, and we have established what those limits are under rules such as AML. So I don't think those are necessarily unique to the crypto space. Those have been tied and tested, and of course they will continue to be under debate, as they should be, as to whether that balance is the right balance. But I think when we often, I guess, think about some of these things as being unique to crypto, and I'm not necessarily sure that they always are.
Yeah, I mean, I think Caroline makes a good point about these issues are ones that always should be up for debate. So we at the SEC have been developing over the last decade a consolidated audit trail, it's called, to track all activity in the options and equities markets. And so it's extreme. It's one of the biggest databases in the world. One of the biggest collections of data. And I've raised questions about that, right? Because if you are just a regular person who's going into the stock market to buy something, why should your transaction be tracked? Why should we, the regulator, be able to track it back to you if we have no belief that you've done something wrong? And I think sometimes we get pretty far down the road on creating something like that before we ask questions about it. So I think Caroline is right. We just need to be debating this. There's always going to be this push-pull between society's desire to stop bad people from doing bad things and people's legitimate interest in keeping their private lives private. And those are the questions are not easy. The answers are not easy. But it's so important that we always be talking about it and be making conscious choices about it, which I think we sometimes cede our financial privacy without really making conscious choices.
So
Sorry for the tangent, but
I agree with the idea that AML's always existed, that financial privacy exists, that it's a right we have, and that there are limits, and that some of those limits are represented in the AML regulatory regime. But the AML regulatory regime only applies in certain circumstances when you're undertaking certain activity. And so when you're interacting with the bank or other covered financial institutions, right? Generally speaking, if I undertake transactions in cash, like buying, something from the garage sale down the street, that's not a covered transaction. And I think somehow there's been an assumption that because crypto's digital, like obviously digital everything has to be under the AML regime. And that's not obvious to me, not at all. And I think one of the maybe things that, and I don't know like what dangers you're talking about, maybe one of the things people find dangerous is that the reports have been used maybe to fuel an expansion of the AML regime to digital things that don't fit in the boxes, actually. But I don't actually think that's Chainalysis' fault, right? That's just how the report has been used. I do worry more broadly about a company producing reports using its own product when the company has like their like own agenda, which is to make money, right? Versus like an academic using the tool to write a report or an article where, like, generally speaking, when I'm taking a position about what the law should be or should expand to include, I, as part of the exercise, you think through the consequences and the challenges and like what one side might use this discussion to do or what the other side might use this discussion to do. Because generally speaking, like at least the way I approach academic writing, I'm trying to be neutral in my assessment of like what my proposal would do, good or bad, in my view, to the world that exists as we know it. And I'm not sure that when a company does that, and this isn't to Chainalysis specifically, but when any company does that, I'm not sure that that's the same thing that's happening. On the other side, though, like other companies have gotten in trouble for letting academics access their data, right? And so I'm not really sure what you're supposed to do. I don't know, like how you get the reports out there except to do it yourself, because you could get in trouble under a different regulation for giving academics access to your stuff, right? So I think you're in a bit of a bind there, and somebody will critique you for something, no matter what. And I appreciate the value of saying like, look, this is transparent data. Look what you can do with it. Because at the very least, it combats the narrative that like, oh, it's all like, you can't tell what's going on there, which is like, oh, it's so super secretive. Like you can't trace it. It's so untraceable. You're showing that that's not actually true. And that is a longstanding narrative that does need to be dispelled. So I appreciate that. And I really don't know what you do about the other critiques, because there will be one no matter which way you approach it, I think.
Yeah, I agree. And I think the dangers that I was alluding to were that just this sort of idea that anybody transacting can be a potential criminal or can be potentially involved in illicit activities. And in that sense, I'd like to ask you, Hester, if you think that the SEC or the government more broadly, I guess the government more broadly, given its recent or like history over the past 10, 15 years, might not be the best. But how do you think the SEC does do a good job at respecting people's financial privacy?
Well, I mean, as I just mentioned, I think in the way we've developed this consolidated audit trail, we've reflected a lack of concern for people's financial privacy. And I think what has happened is that it's now so easy for us to collect, store, and analyze data that the default is to collect, store, and analyze data without thinking about, is this really okay for us to be doing? And I think AI is heightening that problem because AI makes it much easier for us to do large-scale analysis. And when I do raise these concerns around financial privacy and around people's right to live their lives without having the government watch over their shoulder at every financial transaction they make, people say to me, well, Hester, what do you have to hide? Why do you care? Your life should be an open book if you don't have anything to hide. And my response to that is to say, okay, well, then are you really fine with having someone from the government sit in your car with you as you go about and do your errands? No, you want to be able to live your life without having someone watch everything you do. We have laws that we have to enforce, and we need tools to enforce those laws. But I don't think that we should default to tools that are mass surveillance tools when we don't need them to do that job. And so I really urge people to be involved in that conversation. It's important for us as a society to have that conversation and to have voices other than voices that are always saying, okay, let's do more and more and more, because we can now track smaller and smaller transactions without too much trouble. It's easier. That's not the right way to get to the right balance in society. And these are hard conversations to have, because a lot of things that people do with any tool, whether it's a blockchain or a car, a lot of those things are bad, right? And we want to stop people from doing bad things, but we can't in the process give up what we prize so dearly, which is our liberty.
I want to zoom out and ask an open question for each of you, and you can take this in any direction that you want, but and it's the idea, like, what are the deeper issues that regulation might or cannot fix in crypto? Yeah, if there's anything that you see that might be underlying both of the people that are involved in crypto, or this idea that you can't apply any sort of law to maybe what might be a social problem, might be a cultural phenomenon, might be something that's just underwriting the activity of people going on, and that maybe wouldn't require the need for regulation, but might require some specific set of tools in the educational space, in the social capital space, or something along those lines.
Well, I mean, I would say that, you know, there's room for law, but there's also room for morality, right? And we can stop some bad activity before it happens. We can punish people for bad activity after it happens. But stealing from other people and deceiving other people is as old as time. And, you know, I resist the idea that people should always wait for the law to stop them from engaging in bad activity or to protect them from bad activity. You should behave in a way that is respectful of your fellow human beings, regardless of what the law tells you. And as a person who's wanting to engage in crypto, sorry, Carla, to use that, but someone who wants to buy or sell crypto or do something with crypto, you know, put your suspicious, your skeptical hat on and ask questions before you hand your money over to someone who says that she's planning to do something great with it and give you a huge return in a month or a year or whatever it is. You got to ask questions. And so you don't need the law to do that. You just need to think carefully about what you're doing. And so I'm someone who always prizes liberty, but I also prize the idea that people need to exercise responsibility for their own lives and not always run to the government and look to the government to solve their problems. You are the first line of defense.
Would you
think that crypto's broken? I'm a believer, man. I don't know that there's anything I see in the space that like really needs to be solved by law. Actually, rather, I think what cryptocurrency and blockchain technology and the things people are doing with it is showing us spaces where the law needs to be fixed. I think there are large swaths of areas of law that we have not reformed in a real long time. And I think we are showing that it cannot keep pace with technological developments. And that's not crypto's fault. It's just not. The sort of summer of 2020 on debacles that caused all the bankruptcies like that, those organizations were all within regulatory boxes. They were all conducting activity that was regulable, and they still deceived and stole, right? It wasn't a lack of regulation or a failure of law to apply that didn't stop, like it just didn't stop the bad activity. Their law applied and it still happened. Where I think what cryptocurrency and blockchain technology is doing is revealing big flaws and cracks in law that we need to take a hard look at and maybe think of a new paradigm.
I'd perhaps pick up both those ideas and this coming back to, I guess, two things we've mentioned. One, this idea that sort of it's not just looking at the law, looking at things like the, you know, impact of the market, you know, norms, how you establish norms, that sort of idea of the morality of it that Hester was mentioning, you know, code, sort of compliance by design type concepts. And then this idea that we've also touched on in relation to intermediaries. And I think often about the digital asset space as, you know, you sort of have the internet, and it kind of brought this idea of not having a place, not having a single, you know, not this idea of geography that we're so reliant on in so many ways when we make law, that, you know, you're looking for not just an intermediary, but you're looking for that intermediary to be somewhere within your touch points, within your jurisdictions. The internet really challenged us on that front across all different sorts of areas of law. Then you add sort of digital assets. So now we're not just talking about the movement of data, we're talking about sort of the movement of value and of many other things, as we've just discussed. So just to kind of remind us of that. And then, you know, and I think then you add the sort of AI dimension to this. And I think these issues of agents and intermediaries and the lack of location, we are only seeing those challenges grow. And as Carla said, what this is really doing is pointing out areas where we haven't yet met the challenges or the new frameworks that emerging tech is bringing to us. And I think that is going to be a very major challenge, this concept of our traditional look at intermediaries, the globalization aspect, which is only going to sort of heighten over time when you sort of, internet, digital assets, AI, and we sort of end up in quite a different universe than the one that a lot of our legal frameworks were designed for.
Yeah, I totally agree. And I think it's very interesting to sort of see all those changes happen exponentially and how it's going to get a lot tougher for regulators to sort of keep up with the pace of change. And especially when you toss in things like AI into the mix, it's going to get even more difficult. Is AI something that the SEC is also increasingly looking at, or is it still something that's not really considered part of their purview, Hester?
No, I mean, AI has been used by entities that we regulate for many years. And so the most recent technological developments in AI are ones that will affect our industry that we regulate. And so, again, my view on this is until you identify a particular problem that arises from AI that needs a specific solution, I think our existing rules work just fine. We did, though, recently put out a proposal that was directed at AI as well as other technology. And it was, as I said at the time, I was very confused at what exactly we were trying to do, except maybe just stop anyone from using any kind of technology, even spreadsheets. So we're now kind of reconsidering where to go with that. The chairman has said we're going to take a second look at what to do. But I think that rule proposal kind of illustrates the difficulty of trying to come up with solutions that sort of target technology rather than just saying, okay, if people are providing financial advice, it doesn't matter so much what tools they're doing, it matters how they're offering financial advice. Let's look at that. So again, we're considering the comments that we got on that. We'll see where that goes, but that is sort of an example of what we've done on AI.
Well, we're running up on time, and I feel like we could each talk about this for a while longer. But yeah, just to end off, I'd love to open the table if anybody has any final comments or anything that you think that we might have left out of this conversation that you think is important to lay out or that sort of got glossed over, or if you, would just like to leave something food for thought. I'm opening the table for either of you or any of you. And if not, that's totally fine.
Well, I just want to emphasize my door is always open. Commissioner Peirce at sec.gov. If anyone has reactions or thoughts or recommendations for me, I'm open to hearing them.
Awesome. Well, yeah, I can imagine a few emails coming through, interesting ones, and to say the least. But yeah, Caroline, Hester, and Carla, thank you so much for participating today. This has been a lot of fun and really interesting. And look forward to meeting you one day in person and talking about this stuff more.
Thanks a lot, Pedro.
Thanks for having us.
Thank you.